So the webinar will cover a brief refresher on what an SPC is, including the criteria for obtaining one, an update on the most recent CJEU case law. We'll also touch on the 2 pending referrals to the CJEU, and then finally we'll look at what may be next for the SPC regime. So we now move on to the criteria for obtaining an SPC. SPCs for medicinal products are governed by the regulation set out on the slide, which I will refer to as the SPC regulation. Article 3 sets out the criteria, which says an SPC shall only be granted if A, the product is protected by a basic patent in force, and we'll come on to see that the definition and interpretation of product is quite key here. A valid marketing authorization to place the product on the market has been granted. The product has not already been the subject of an earlier SPC, and the MA referred to in Article 3B is the first MA to place the product on the market as a medicinal product. So under the SPC regulatory framework, intellectual property offices of EU member states are responsible for granting SPCs. The intention was that because the offices were implementing the same regime, this would lead to consistent results. However, there have been many discrepancies between the application of the regulation in different territories and difficulties in applying the regulation, which has led to a number of references to the CJEU seeking guidance on, in particular, the interpretation of Article 3. So after Santin, the SPC referral landscape went relatively quiet for a few years before we saw at the back end of 2021, we saw the Finnish Market Court make a referral, and then in February of 2022, the Irish Supreme Court also made a referral, the substance of which overlaps somewhat. So in summary, both courts see that there is apparent discrepancy in the CJ case law to date with respect to the interpretation of product in the SPC regulation and its application in Articles 3A and 3C, and are seeking guidance in this regard.